Okay. Are we ready?
Should be all set.
We haven't had the testing done, but if you want to go ahead and get started, that's fine.
Okay. We will kick it off then. All right. Good morning. I'm Ward 1 Councilmember Brianne Nadeau, the Chair of the Committee on Public Works and Operations. Today is Thursday, February 9th, 2023, and I'm calling to order this meeting of the committee to conduct a performance oversight hearing for the Office of Human Rights and the Commission on Human Rights over the Zoom platform. The time is 9:35 a.m., and I'm joined by my colleague, Councilmember Robert White, who will be recognized for remarks after my statement. This hearing is being live streamed at brianneknadeau.com/committee. Today's performance oversight hearing is for the Office of Human Rights and the Commission on Human Rights. The Office of Human Rights is an important agency, and its primary function is to enforce the DC Human Rights Act and other local and federal civil rights laws. The Human Rights Act is a critical piece of legislation. It makes discrimination illegal based on 23 protected traits for people that live, visit, or work in the District of Columbia, in places of employment, private companies and government, housing, public accommodations, and educational institutions. But the law is also flawed in its application. So I'm sure today we will hear from public witnesses with ideas on how to refine its protections in the agency's complaint process. The Office of Human Rights is charged with providing a legal process to those who believe they have been discriminated against. It offers a right to sue in DC Superior Court and/or an opportunity to seek administrative remedies before the Commission. For example, a person who believes they've been unlawfully discriminated against may file a complaint with the Office of Human Rights. The agency then schedules an intake interview. An attempt at mediation is tried, and if there's no resolution of the dispute, the Office of Human Rights moves forward with an investigation to gather the facts. After the investigation, the attorneys at the agency present the director with the information. Ultimately, she decides whether to issue a letter of determination that there is a finding of probable cause to show a Human Rights Act violation that has occurred and to move ahead with formal charges. Then the Commission on Human Rights takes over the process. An administrative law judge presides over an evidentiary hearing and provides a recommended ruling in any penalties that may apply. Finally, a panel of commissioners provides an independent perspective and renders a final decision. The process, as I illustrated, sounds straightforward, but it's not. Discrimination complaints take substantial time to litigate and can become easily complicated, especially for the pro se litigants. We will explore these challenges, among others, in today's hearing. I thank the Office of Human Rights and the Commission for their responsiveness to this committee's request for information. I look forward to hearing more about the challenges the agency faces so we can help them work through them to fulfill its mission to eradicate discrimination in DC. We will be hearing specifically from the Director of the Office of Human Rights, Nin Kane, who was recently confirmed for the position. Congratulations, Director. We will also hear from Motoko Ozawa, Chair of the Human Rights Commission, and Chief Judge Erica Pearson. We value your input and we are grateful for all that you do for our residents. I'll now turn to at-large Councilmember Robert White for an opening statement before I return to some logistical announcements.
Thank you, Chairperson Nadeau, and good morning to you and everyone else. Unfortunately, I'm leading my own committee oversight hearing this morning, which happens this time of year, so I'll have to step out in a few minutes. But I wanted to join this hearing momentarily on the Office of Human Rights to highlight a few items. First, I just want to mention that I'm excited to be on this committee and particularly excited about Councilmember Nadeau's leadership here. I really enjoyed work in progress that we made with the Office of Human Rights and with the Commission over the past several years. And I think Councilmember Nadeau is incredibly thoughtful and smart, and I'm looking forward to see where she carries things forward, because there certainly still are challenges. But to help with those challenges, I'm also happy and want to congratulate Director Kine on your confirmation by the Council as the permanent director of OHR this week. As most of you know, I chaired the Committee on Government Operations and Facilities last council period, which had jurisdiction over OHR, and I always appreciated working with Director Kine and with the agency, and was particularly impressed by Director Kine's efforts to address case backlogs. While I can't stay to ask my questions directly, I would ask that OHR provide the committee with progress updates on the implementation plans for measures that passed the council in the last council period, including the Human Rights Enhancement Act of 2022, which added homeless status as a protected trait and enhanced protections for independent contractors and workplace harassment. This measure became law on September 21st of last year. The second is the Sexual Harassment Data Collection and Reporting Act of 2022, which requires DC government agencies to track internal sexual harassment complaints in OHR to compile and submit an annual report to the council and the Office of the Attorney General. This bill became law September 21st of last year. The third is the Attorney General Civil Rights Enforcement Clarification Amendment Act, which provides the Attorney General with investigative and enforcement tools to fight discrimination pursuant to the Human Rights Act. This will require greater coordination between OHR and OHG to successfully implement this act. The two agencies have worked together for some time to get us to a final bill, and this measure became law on March 16th, will become law on March 16th of this year following congressional review. Finally, I want to note that we had the opportunity to fund the Domestic Workers Employment Rights Act of 2022 in the upcoming fiscal year 24 budget cycle. The council passed the measure at the end of last year to expand employment rights to domestic workers who have been historically left out of legal protections that most other employees benefit from. It's important that the council and the mayor work together to fund it so that OHR can implement it smoothly. And I had no doubt that the Committee on Public Works and Operations will work closely with OHR to ensure that these recent changes are thoughtfully implemented. Again, Chairperson Nadeau, thank you for holding this important hearing. To agency, commission, and public witnesses, thank you all for joining. I look forward to getting a recap and reviewing the hearing later.
Thank you, council member, and thanks for the warm handoff with our new responsibilities here in the Committee on Public Works and Operations. Teamwork, that's right. I'm going to now provide some logistical announcements for today's hearing. So as I mentioned, in addition to the Zoom, the hearing is being live broadcast at briannecanedo.com/committee. To ensure we hear from all members of the public, I'll ask that all witnesses stick to their allotted time. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all other witnesses will have 3 minutes. Let's see. We are going to call up only one panel of public witnesses today, and then we'll follow that by with testimony from our government witnesses. I'd also like to provide some detailed reminders about the Zoom platform and the committee's protocols for the witnesses participating today. So all witnesses participating in the webinar are currently attendees in Zoom. That means your microphones are muted and your cameras are turned off, but when it's your turn to join the panel, I'll call your name. You'll be promoted by a member of my staff. And then when it's your turn, you're welcome to activate your video, and you'll need to unmute yourself by using the microphone button. Remain muted until it's your turn. For any technical difficulties, you can send a message to David Menny, Sabrine Katie, or Eric Irving, labeled as Committee on Public Works and Operations, and they will follow up with you. Additionally, if you're having trouble gaining access to the Zoom and you've pre-registered, you can reach my team at 202-741-2111, and they will try to resolve your issue. So let's turn to our first panel. It's our public witnesses. That includes Sophia Mitchell, policy attorney, First Shift Justice Project, Susie McClanahan, senior manager with Fair Housing Rights Program at the Equal Rights Center, Alana Eichner, co-director of the DC chapter of the National Domestic Workers Alliance, Erica Sklar, organizer of Hand in Hand, Lauren Corey, president-elect of the Metropolitan Washington Employment Lawyers Association, and Michael Syndrome. All right, Ms. Mitchell, when you have a chance. Oh, there you go. When you're ready, go ahead.
Good morning, and thank you for the opportunity to provide testimony regarding the performance of OHR. My name is Sophia Mitchell, and I am a policy attorney at First Shift Justice Project, a nonprofit legal organization with the mission to help working parents assert their workplace rights to prevent job loss. First, I would like to begin by expressing our excitement about the newly passed DC Domestic Worker Bill of Rights and inquire about OHR's next steps in establishing written guidance documents about common forms of discrimination in the employment of domestic workers and guidance for employers on how to comply with the DCHRA. We would like additional information on the current timeline OHR has in place to meet these goals, how OHR plans to make the website user-friendly and accessible to people who speak languages other than English, and what OHR's outreach strategy will be to make sure people know about these important protections and valuable informational resources. We hope to learn more about OHR's plans in the upcoming months and would be happy to share any knowledge we have gained through our work on the paid family leave program that may help in establishing guidance materials. Next, I will highlight 3 topics that we believe will improve and strengthen the enforcement of the DCHRA, although I will only go into detail on the first 2 for the sake of time. First, First Shift recommends incorporating the Protecting Pregnant Workers Fairness Act into the DCHRA. The PPWFA works to protect pregnant workers against discrimination in the workplace by allowing pregnant workers to request reasonable accommodations that enable them to continue to work for the duration of their pregnancies and by allowing them to access job-protected leave to recover from childbirth. At First Shift, we often advise workers that have been at their job for less than a year and are not protected by the federal or DC FMLA, but they are entitled to leave to attend to their pre- and post-pregnancy medical needs under the PPWFA. However, the protections under the PPWFA are not accompanied by an enforcement framework that includes strong remedies in the case of an employer violation. While an individual experiencing pregnancy discrimination can receive back pay, reinstatement, and attorney's fees under the PPWFA, there are no additional damages that an aggrieved employee can seek to hold their employer accountable for unlawful behavior and deter DC employers who would rather terminate a pregnant employee instead of approve a request for a reasonable accommodation. We believe that pregnant workers would be better served and employers would be more likely to follow the law if the more expansive remedies provided under the DCHRA were available to pregnant workers who are denied reasonable accommodations or retaliated against for requesting them. For those reasons, we recommend incorporating the PPWFA into the DCHRA. Next, First Shift recommends including childcare and caregiving responsibilities as a basis for reasonable accommodation for individuals experiencing domestic violence under the DCHRA. Last year, a client who was experiencing domestic violence came to us seeking legal assistance after being terminated from her job. The client informed her employer that she was experiencing domestic violence and requested an adjustment to her schedule to attend her court date to meet with her social worker and care for her daughter. The client was staying in hotels and domestic violence shelters, and she needed to be available to care for her daughter in the afternoons. Instead of granting the scheduling adjustment and giving our client a morning shift, her employer reduced her work hours and told our client to bring her daughter to work. She complied with these instructions because she had no choice. However, on the 3rd day, she brought her child to work with her. She was terminated for unspecified reasons. The DCHRA grants reasonable accommodations for a person experiencing domestic violence to ensure the person's security and safety. However, we believe that a direct acknowledgement of child care needs and adjustments to child care arrangements would empower domestic violence survivors to request reasonable accommodations that allow them to address the broad range of issues that they have to deal with as they seek to get their lives and their family life back on track. We recommend adding language to the DCHRA that specifies the need for leave to attend to childcare needs and make adjustments to childcare arrangements for individuals who have experienced domestic violence. Finally, First Shift continues to advocate for the elimination of the election of remedies requirement under the DCHRA. We hope that the Fairness and Human Rights Administration Amendment Act of 2022 is reintroduced to remedy this issue. Thank you for your time.
Thank you for your testimony. We'll now hear from Susie McClanahan.
Oops. There we go. Great. Hello, I'm Susie McClanahan, the Senior Fair Housing Rights Program Manager at the Equal Rights Center. The ERC appreciates the opportunity to testify for the performance oversight hearing of the Office of Human Rights. The ERC is a civil rights organization that identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in our home community of Greater Washington, D.C. and nationwide. For many years, the ERC has conducted intakes with individuals alleging housing discrimination in D.C., investigated individual claims and systemic forms of housing discrimination, pursued enforcement of the Fair Housing Act and D.C. Human Rights Act as needed, and conducted education and outreach about fair housing protections and requirements. The ERC, as a complainant or non-attorney representative for individual complainants, has filed about 30 housing discrimination complaints with OHR in the last 3 years. The ERC commends OHR on the increase in fair housing complaints docketed at the agency last year. In fiscal year 2022, OHR docketed 72 fair housing complaints, almost double the year before. Complaints will also likely further increase due to OHR's new areas of enforcement from legislation passed last year, which included the strengthening of source of income protections for voucher holders and the addition of 2 new protected classes in housing. Yet as the number of complaints grow, there are significant concerns about OHR's ability to keep pace. 5 ERC clients currently have open complaints that are more than a year old, with the oldest one dating back to 2020. With the departure of one of the agency's 2 housing investigators last year, delays in the administrative complaint process have worsened, with some fair housing complaints appearing to come practically to a standstill. These concerns about OHR's administrative complaint process are unfortunately not new. Many complainants over the years have shared that the complaint process is time-consuming, resource-intensive, and confusing, to the extent that it deters them from filing or following through on complaints. OHR has stated its plans to use fact-finding conferences during investigations in order to decrease the growing backlog. While the ERC appreciates OHR's intent to address the complaint backlog, we're gravely concerned that fact-finding conferences could make the complaint process more emotionally draining and difficult to navigate for complainants. The ERC helps individuals file housing discrimination complaints at 5 local, state, and federal government agencies in its service area. Of those, only 1 agency has previously used fact-finding conferences. In a fact-finding conference, the investigator holds a meeting with both the person who filed the complaint and the housing provider against whom a complaint was filed, and the investigator asks questions of and takes statements from both parties while they are together. Our experience has been that victims of discrimination frequently find it difficult to clearly articulate their experiences in such a high-stress environment, especially when there can be such a significant power imbalance between them and the housing provider. One ERC client that participated in a fact-finding conference called the experience more traumatic than her experience of housing discrimination. Rather than instituting fact-finding conferences, we respectfully suggest that instead OHR hire and train more staff to process complaints. The challenges with the complaint process highlight the heavy enforcement burden put onto individual victims of housing discrimination. With fair housing complaints frequently taking 1 to 3 years to reach a resolution, individual complainants are required to relive the discrimination they experienced over and over as their complaints slowly progress through each stage. As such, it is critical that the district civil rights enforcement agencies, including OHR, do everything in their power to fight discrimination at a systemic level. The Fair Housing Act and DC Human Rights Act allow for fair housing claims based on a disparate impact theory. Policies and practices that appear neutral could be considered discriminatory under a disparate impact analysis if they have a disproportionate impact on a group of people protected by fair housing laws. Disparate impact provides a powerful tool to address systemic forms of discrimination because it makes possible to identify and challenge more pernicious, difficult to see cases of discrimination. Yet OHR's director stated during their performance oversight hearing in 2022 that the agency does not accept disparate impact claims because they are resource intensive and the agency lacks the staff capacity necessary to investigate such claims. In order to effectively address the systemic discrimination, OHR must take the necessary steps so that it can accept fair housing complaints based on a disparate impact analysis. Relatedly, OHR could more proactively address housing discrimination and reduce the burden on victims of discrimination by conducting director's inquiries. In 2021, OHR opened only 1 fair housing related director's inquiry. Yet blatant housing discrimination occurs in the district with frequency, especially on the basis of source of income. OHR should fully use its authority to launch director inquiries in order to respond to rampant source of income discrimination. Thank you for this opportunity to testify.
Thank you very much for your testimony. We'll now hear from Alana Eichner.
Good morning, council member. I'm excited to be here today because for the past several years at this same hearing, we've asked for a change to the law to make sure that domestic workers are included in Human Rights Act. So it's really exciting to be here now that that law legal change is in place to talk about how we can implement it and make it real in the lives of domestic workers. And we're really grateful to have had your strong and consistent support throughout this entire process to pass this law. So as you know, OHR has partial responsibility for implementing this law along with the OAG's office and along with the UAS, and OHR has kind of what I think of as the most signature part of the Domestic Worker Rights Employment Act, the inclusion in the human rights law in the employment discrimination protections. There's just a few things that we want to flag from the perspective of domestic workers in DC that we hope OHR will do to make this law real in the lives of domestic workers, and that we hope you and the other committee members will push OHR to implement effectively. From our perspective, to make sure that this law is real for domestic workers, that means that they have to know about this new right and have to be able to easily take steps to receive remedies and justice if their rights are not respected. We see this as including widespread public outreach in the community, and we suggest that OHR does this in collaboration with community groups that already have experience working with domestic workers and employers of domestic workers, and lean on those groups' expertise to publicize guidance targeted toward domestic workers and employers. The statute says that OHR has to put out guidance about common workplace discrimination for those who work in private homes for both employers and workers. And we think it's really essential to partner with community organizations to make sure that guidance actually reaches workers and employers. I just want to emphasize what Sophia already mentioned about resources being in multiple non-English languages. I know we have language access laws in DC, but across agencies, too often documents are not translated, they're not translated consistently, or they're not translated correctly, or agencies are relying on Google Translate, which doesn't give a fully accurate translation. And to just emphasize, which I know you know, that a huge percentage of domestic workers in DC are not native English speakers or not English speakers at all. And so ensuring that any and all documents, materials, webinars that happen through OHR aimed at guidance for this law really have to be done well vis-a-vis language justice. And the last thing is just to speak to the complaint process. I think OHR could do more to make it an accessible and non-intimidating process for workers. And again, I think a lot of that could come by partnering with community organizations who already have the trust of workers. We would love to see the process of how you file a complaint well publicized in the community, again, in multiple languages, and kind of for OHR to think critically about how to make this a welcoming, non-intimidating process as much as possible. And a lot of the domestic workers that we work with don't have access to a smartphone or don't have other technology experience. And so making sure that accessing the complaint process can be done with as minimal technology as possible will also ensure that this is a process that can help make this right real. We would love to hear from OHR about what the timeline is, like Sophia said, about their plan to issue guidance required under this new law about discrimination for workers and employers in private homes, and to hear more about OHR's plans to make sure that this guidance and awareness of a new right under the law is widely understood in the community, and how to make sure that any materials they put out are available to those who are non-English speakers or have low technology skills. I remember several years ago, one of our members, Ingrid, told a story about experiencing sexual harassment at work at this performance oversight hearing, I think in 2019 or 2020. And it's really exciting all these years later to be back to talk about the implementation. So we're really excited to work collaboratively with you and with OHR members of the committee to make sure that the promise of this law really is tangible in the lives of domestic workers. Thank you.
Thank you. Appreciate your testimony. We'll now hear from Erica Sklar.
Hi, good morning. Thank you for the opportunity to testify this morning. My name is Erica Sklar. I work as an organizer for Hand in Hand, the Domestic Employers Network. Hand in Hand is a network of employers of nannies, home attendants, and house cleaners who are working for dignified and respectful working conditions. As you know, a broad base of employers and placement agencies in Washington, D.C. have been supportive and vocal around the Domestic Worker Employment Rights Amendment Act. So we're really excited to be here today to talk about the implementation of the policy. The Office of Human Rights will have a really critical role in developing, maintaining, and making available written guidance about discrimination that employers really need to be aware of. And we know from many conversations with employers around the district that they want to do the right thing and they benefit really deeply from guidance like this that's available to them. They will need to be reached where they are, which is at work, around schools, faith-based organization, and in their homes in order to fully implement the policy. Employers are a disparate group of people employing folks in their homes. They're behind closed doors, and outreach campaigns that include community-based organizations will ensure that employers understand their responsibilities and know where to look for information that will be really critical to the full implementation of this policy. The other thing about employers is that frequently, by the nature of needing additional help at home, they are short on time or they have limited access to technology or information. And that's why it's really critical that resources are made fully available to employers that are very simple, simple to find and easy to read and implement in their homes without additional support from a third party. Employers also are always looking for very clear and, as has been noted, language accessible information that they can share with the people that they employ. Employers want to see this policy fully funded and implemented so that they can go from doing what they think might be the right thing and hoping that they've made good decisions to having real clarity that the city has supplied them with the resources they need to be the kind of employer that they want to be. And finally, employers want to see full implementation and proactive action on this policy because in so many ways, the really good and great employers in the city who want their homes to be safe, ethical, and excellent places to work suffer from the actions of their peers who maybe don't share their values. So they are anxious to see full enforcement of the policy, including proactive investigation that weeds out household employers who are maliciously out of compliance. I'm very happy to answer any questions about domestic employers or the way that Hand in Hand has supported around similar policies that we've seen around the country. Thank you for your time.
Thank you. We will now hear from Lauren Corey.
Good morning. Thank you for the opportunity to testify. I'm here on behalf of the Metropolitan Washington Employment Lawyers Association, also known as MWELA. And we're an association of over 300 attorneys whose practice is dedicated to representing employees and the advancement of civil rights in the workplace. So much of our practice is before OHR and other administrative agencies that are like OHR in the DC, Maryland, and Virginia area. The council has consistently worked to ensure that the District of Columbia Human Rights Act, the DCHRA, remains one of the most robust anti-discrimination statutes in the country. And in the last year alone, the council has made very important changes that we are very great, that us and our clients are very grateful for. And listening to Council Member Robert White tick through those in his opening statement was very wonderful. You all have been busy. And we're very grateful for the changes that have happened just in the last year alone. So today I'd like to focus on two issues: OHR's processing of complaints and additional changes that we believe are needed to make the DCHRA a more effective tool against discrimination in the district. First, in 2019, OHR launched the pilot program guidelines for accepting attorney drafted charges in public accommodations and employment claims, which we believed was an important first step in simplifying and improving the process for complainants. Our members, however, have not seen an improvement in charges being accepted more efficiently. I know that the pilot program launched for a period of time, and there was an intention of launching it again But this is before the pandemic, and multiple changes and restructuring happened as a result of the changes that were sort of necessitated by the pandemic. But after we polled our members in anticipation of this hearing, and their experience is that the difference in intake time when compared to the EEOC, the federal agency, for example, is a delay in at least 4 additional months when filing a charge with the Office of Human Rights. If the reason for this delay is resources, we ask that OHR receive additional funding. In years past, when we've raised this concern about delay, OHR has stated that some charges that are being submitted may be missing information that they need to process their complaints. And if that's the case and a source of some of the delay, we look forward to working with them to remedy that delay and discrepancy, and working on community outreach to ensure that both attorneys that are working with clients, but also the members of the community who may be coming to OHR without attorneys have the information they need to be most effective in asserting their charges. Another concern that we have is that we've raised concerns in the past about the way OHR is processing complaints that are contrary to law of the District of Columbia, and have heard within the last month that some of these things are still happening. For example, in 2018, we raised a concern that the Office of Human Rights was dismissing hostile work environment claims when instances of harassment were not happening in the 1-year statute of limitations period, where DC law is clear that as long as one incident has happened in the last year, the entire hostile work environment claim is timely. It's concerning that this is something that we had raised before and is hearing that is still happening today, in part because the law is clear on this issue, but also because it's a concern for people that may be coming to the Office of Human Rights without attorneys and don't know to push back on this issue and are losing their right to pursue their claim. My written testimony goes into other details about individual defendants and honoring tolling agreements, but I'll leave that there for purposes of today. The issues that we want to discuss regarding changes to the Human Rights Act that we think are necessary to improve the functioning include getting rid of the election of remedies portion of the bill. Chairperson Nadeau, you and other members of the committee introduced the Fairness and Human Rights Administration Act in September of last year. We think that that's critical to improving the functioning and should be passed. We also agree with what Sophia and Alana mentioned regarding domestic worker enforcement of the new domestic worker provisions, and look forward to working with OHR to ensure that the promise of that law is realized. We also believe that the statute of limitations for the DC Human Rights Act should be increased, that the Pregnant Workers Fairness Act should be incorporated to the DCHRA. And lastly, what hasn't been mentioned today is improvement around the tipped wage workers fairness program and ensuring that that's implemented effectively. Thank you so much.
Thank you. We will now hear from Michael Syndrome. And Mr. Syndrome, since I know you can't see the clock, I'll let you know when you hit your time.
Right. It should be 5 minutes. Justice for All, DC, Madam Chair. Michael Syndrome, disabled veteran, served our country more than most. You sound well. So the Office of Human Rights has been problematic, as pointed out, with docketing charges. That seems to be done to lessen their caseload, and it irreparably harms the community. Sad but true. And filings as of right to be rejected by the staffers at the front desk, David and Eva, ought not be. As of right to file, and it's to be taken under advisement, not by the receptionist, but by OHR qualified staffers. Nin Khan acts as a number of capacities there. General counsel, acting director, so on and so forth. She's come forward with some really nonsensical law indicating cases are dismissed for quote unquote convenience sake. I've never heard of such foolishness. It irreparably harms we the people and ought not be. Also, they continually administrative dismiss complaints without the required in-office interview, and that is legislative intent so that what I as a layman or we the people would miss a qualified experienced investigator, would pick up and add it to the charge. But that's not happening on a regular basis, very infrequently, actually. On a personal note, I've had intake, and in the past, they would proceed to mediation. Very rare now. It's, again, administrative dismissal. And the alternative to combat that, collaterally address, is through motion to reopen, which is the police policing themselves, or go to court, which is expensive, time-consuming, and the comeback from the court would be you haven't exhausted your administrative remedies. So round and round we go. Specifically, I have a case with American Pest, and it was an OHR inquiry number 16377. I had intake, and I understand it's to be slated with Human Rights Officer Alex Taylor. It's now been pending years. Haven't heard as to the charge being drafted for me for signature, which ought not be, and that is not good. There's also a letter that I wrote to a number of folks dating back to 2020 when Michelle Garcia was interim director, and then Monica Plosio come back, and now Nin Khan. Nothing's been done. A number of closures where reopenings have been requested, but nothing has been done, remain pending and acted upon. Indeed, justice delayed is justice denied. There is another inquiry number 15590, Michael Syndrome v. Oregon Pest Control. It was alleged that the office sent me questions which I never received. So based upon that, the case was improvidently closed. I've since written back June of last year saying I've never got the questions, get them to me and I'll respond. And the only comeback was a slap in the face. Well, it's closed, nothing more can be, will be done, goodbye, have a nice day, don't come back. That clearly puts folks on notice that when the cat's away, the mice will play. And the OHR to combat discrimination is really aiding and abetting with impunity. And folks know on the street, when you hear OSHA, businesses quiver. And the comeback is, what will it take for you all, to go away? And so OSHA will tell them. But OHR, you mentioned on the street, people laugh. They don't even know what's going on. With regard to the commission, director too, she has the purse strings controlling the finance, not only of the office, but also of the commission. That ought not be. And also, the director of Office of Human Rights does the evaluation for the Commission on Human Rights. And I would like to know, too, when they're going to reopen for personal testimony, which they had pre-COVID, and it's time that they do that now. And so I'd like for the committee and you, Madam Chair, to address these issues in seriam and, have a response from OHR, because when I ask, it falls on 10 ears, and that ought not be. And the mediation is a golden crown jewel, mandatory mediation. But the administrative dismissals undercut that so that the mediation never takes place as required by law, and that ought not be. Also, the Human Rights Act has a provision for injunctive relief under DC Official Code Section 2-1403.07, which is very rarely, if ever, used. That ought not be. That is a mechanism. And also, OHR has the capability to pursue a claim in court. They rather defer to the Attorney General, and they're overwhelmed as well. That ought not be. It's do-over work.
Mr. Syndrome, I'll have you wind down now with your little over 5 minutes. So just if you could wrap us up and we'll turn to the panel.
OHR should be able to take the bull by the horns and address complaint in court. So again, American Pest, inquiry number 16377, waiting for the charge to be filed, docketed, and then sent to me for signature. Then we have AmeriHealth Caritas 2, which the complaint remains pending and unacted upon. That has been since July of last year. I made mention about Oregon Pest Control, inquiry number 15590, that's been pending and acted upon for years. And then the letter to Ms. Khan. That still remains pending and acted upon, and I'll forward that to the committee so they can have it and have Director Khan respond accordingly. Thank you, Madam Chair. Any questions? I'd be delighted to field them at this time or when you see appropriate.
Thank you so much. And we're going to follow up with you on those items as well. We appreciate you. We have one more panelist joining us. That is Reginald Black. We're just going to get him promoted and then he will have his, there he is. Great. Reginald, when you are ready, you may begin. You may unmute yourself and then turn your camera on if you wish. Mr. Black, are you ready for us? All right, well, just in case he's having some technical difficulties, we will give him a minute, but why don't we dive in with questions for the panel? Okay, so we had some testimony about pregnant workers, about housing, fair housing complaints, about the implementation of the Domestic Workers Act, operational concerns. So let's dive in first with Sophia Mitchell. Sophia, are you, can you talk me through, so you're talking about adding pregnant workers into the DC Human Rights Act. Is that something that's done in other jurisdictions where we have a model for that?
That's something I'm not sure, but that's something I can circle back to you about.
Yeah, great. It'd be good to know. You know, my concern about adding something to the Human Rights Act right now is the operational challenges that we already have. And I want to make sure if we add something, it's going to be a meaningful change, that there's actually capacity to do that enforcement. And if there are other ways of doing that enforcement currently under the law, but they are not working, then I also want to look at that and think through how do we make that work before we make a change. And I'm absolutely willing to go deeper with you on that. And if you have thoughts on sort of that dichotomy, feel free right now. We're here. So.
Yeah, so we believe it would better serve pregnant workers to be in the Human Rights Act because it has stronger remedies and protections for workers. So as it currently stands, the Protecting Pregnant Worker Fairness Act, some of the remedies that are included are back pay, reinstatement, and attorney's fees, but there are no other protections to, for example, if an employer, I'll start by saying this, at First Shift, it's important to us that we are educating employers and employees as well. So we want to make sure that people are aware of the law. But, you know, for circumstances where an employer is aware of the law and they are not acting in good faith, it'd be helpful to have punitive damages so that they are held accountable for their unlawful activity, as well as to deter other DC employers from behaving in a similar manner.
Okay, that's helpful context. Thank you. Thank you for helping me learn about all of these things in our new committee. Truly appreciate that. And then Susie McClanahan, thank you very much for your testimony. So the delays, I think, are the big thing here. And then also just sort of other remedies being offered or other paths being offered, you think are not satisfactory.
Hello, good morning, Councilmember Nadeau, members of the committee. My name is Reginald Black, and I serve as the Housing Policy Advocacy Director for Serve Your City Ward 6 Mutual Aid. And I'm also a Ward 4 resident. We are here today to support Section 23 of the Human Rights Enhancement Act in which it is a crucial protection for those who are experiencing housing instability and or homelessness by adding them to each and every protected trait to the DC Human Rights Act of 1974 on many different perspectives, including our annual Homeless Person Memorial Day and Vigil. We work with the late, great Michael A. Stoops to make this a reality. The homeless community is a vulnerable community in which things go wrong during the course of the day, and we must ensure that there is proper implementation of Section 23 of the Human Rights Enhancement Act of 2021. A lot of these suggestions include enabling different agencies to streamline the Office of Human Rights complaint intake process. Examples of these are agencies like the Department of Behavioral Health, the Department of Human Services, MPD, etc. This is to alleviate that women face up to 50% or more discrimination from places like social services and medical facilities. We also want to encourage significant funding increases to implement investigations. There was only 500,000 when the Human Rights Act was still introduced as the Michael A. Stoops Anti-Discrimination Act. We would like to see at least $1 million every year to support investigations of each and every protected trait and the addition of homelessness. And we would love to see reports as to the last fiscal year of how many cases were both reported as homelessness and any one of the 21 protected traits. We'd also like to encourage all of our social services to incorporate racial equity lens and provide a clear understanding and guidance of their role in the experience of discrimination, policies and action steps that will reduce discrimination while accessing services, and how agencies can assist to mediate, advocate, and remedy such experiences. These discussions happen in every conversation of inclusion in DC, and we want to make sure that Section 23 is the most effective tool we can use to help our people who are unhoused transition into a more stable environment through mediation and or litigation if necessary. This is a framework to make the District of Columbia more of a world-class human rights city. And we look forward to the chance to working with your office and the Office of Human Rights and all of our community to make sure that we provide the protections that every other subpopulation protected under the DC Human Rights Act is afforded. I thank you for the opportunity to testify, and I'm happy to answer any questions you may have.
Thank you. Glad to have your testimony. And if you haven't already submitted it in writing, please do email it to us so we have it for the record. Okay, so I'll come back to you. I was just chatting with Susie McClanahan. You mentioned, sorry, we were talking about the delays. And then also something that stood out to me was just, you pointed out that the fact finding conferences are really draining for complainants. So what is the ideal, if you can walk me through, what would the ideal scenario be for someone who's filing a fair housing complaint as compared to what the experience is right now?
Yeah, I will note that OHR has not currently implemented fact-finding conferences, but it is a proposal they have, and we have grave concerns about it.
Okay.
But right now, there are just significant delays at every stage of the process. So to give an example of a current client, their case underwent mediation last April, and the investigator reached out to start the investigation of his complaint a couple weeks ago. Right. And so you have an individual experiencing housing instability whose complaint is based on a written discriminatory statement, who is being asked to wait essentially years in order to have a full investigation of his complaint at this point. Mm-hmm. So there's just significant delays every single stage from intake to mediation to the investigation. And the investigations themselves appear to be taking, anywhere from 12 to 18 months alone. And so it's just asking someone to sit and wait. And many folks, that's just not viable, kind of given their circumstances.
By the way, I forgot to mention my sister used to work at Equal Rights Center in the Fair
wonderful.
Housing Program right after college, which is longer ago than she would like me to admit, but it was a very important experience for her, and I learned a lot when she was doing it. So just so I can understand too, like what happens even before a complaint is coming to OHR in this situation, and what is happening to the resident during all of this time. So you all are investigating, you're doing proactive. Do you still do the proactive?
We directly assist folks who are alleging discrimination, and we also do systemic investigations.
That was the part that I remembered. Okay. So when you're assisting somebody who's alleging fair housing violation, is this somebody who is being barred access to housing? Is it somebody who's in housing already? What is going on with your client at that point?
So when we do an intake with an individual, we obviously get a sense of their allegations, and we offer them, various options, including notifying them of their right to file a complaint with OHR or the appropriate agency, or directly assisting them to try to address whatever the issue is, which the vast majority of the time, individuals just want the situation resolved. And that could look like, for instance, a voucher holder being told that the place doesn't accept vouchers, where, they're not applying the application requirements properly to voucher holders, things like that are barring them from the property. It could be a resident in housing who the person has a disability and needs assistance getting an accommodation. We've had several harassment intakes where folks are living at a property and either experiencing harassment from the housing provider directly, or the housing provider isn't preventing harassment from occurring, even though they're aware of it. And so if we are unable to resolve the issue via kind of direct educational attempts with the housing provider, some clients will then decide to pursue a fair housing complaint. So we will assist them with filing at OHR and then go through the process with them.
So for your client that had a mediation in April and the investigation just started last month, what is the person's living situation right now?
They are desperately trying to find a unit that better meets their family's need, where they'll take a rapid rehousing voucher. Well, they may have a permanent voucher now, but the initial issue was over rapid rehousing.
And they couldn't find, so they're in a place that where they feel that they are at risk, but they have a government subsidy available to them to get them out of that situation, but they're being discriminated against because of their source of income. Okay. And the mediation is with the landlord who is not accepting their voucher.
Correct.
So they want that place so badly that they're waiting this long in that situation that's being held up by OHR.
The unit's already off the market. Essentially, once it became clear that they weren't going to rent to that person and they rented, it's very common for us to see where, in order to avoid renting to voucher holders, they find another tenant pretty quickly, right? Because then they just simply can't address the issue since the unit's already filled. And so in this case, we filed the complaint, we went through mediation, and then the mediation was unsuccessful. So it was supposed to be forwarded to investigation. And technically the respondent first issues a position statement to the investigator. And once they receive it, the investigator then contacts the complainant to get kind of their rebuttal response and schedule an interview. And so they're supposed to, from mediation, usually respondent has about a month to submit the position statement. They submit it within a month of getting the initial notification of the complaint, and mediation is occurring during that time. So their mediation occurred last April. We were contacted by the investigator in January, actually, just kind of start the investigation on the complainant side.
So the apartment's gone. They're still looking, I assume. What is the remedy for them with this original apartment?
Most of our clients at this point, because the units are no longer available, are seeking some form of monetary compensation for the harm that they experienced. And I mean, what I hear from client again and again is that they're filing complaints because they just don't want anyone to ever go through this experience again.
So they're kind of doing it at this point for the public good. I can't imagine the monetary award would be substantial enough that it's worth going through all of this. Although, what do I know? Is it typically? I mean, we usually see complaints settle for somewhere like between maybe $3,000 to $8,000. Oh, okay, that's significant, and can help a family that's been through a lot significantly. I mean, that can be several months' rent, or car, or whatever the family needs. Okay, so that's really interesting, because it seems like it's a lot of effort for somebody who's already going through something when it's not going to change the outcome of that particular instance, but it could help someone else. So that is, it's really helpful to understand. Well, and the other piece, I mean, obviously from the government standpoint, we want it to stop. Presumably this process teaches the landlord something. Well, and the clients that we work with almost always want some form of like injunctive relief. So they are asking for the landlord to take training on housing discrimination laws. They're asking for them to have a non-discrimination policy. And to some degree, I believe OHR would generally require that of a housing provider as part of a settlement, that they complete steps similar to that. And despite the delays in the process that you've outlined, when a case goes all the way through to completion, do you generally see the remedies being what you would hope? I mean, it's hard to say. Ultimately, clients who are able to settle their cases are generally satisfied by the resolution, but the process itself is extremely taxing. And I especially worry about folks that may simply not know that there are other organizations that could help them through the process. Yeah. And the complexities of navigating it, because we do a lot of direct advocacy with our clients where we are talking them through the entire process. This is what's happening next. This is what's expected of you. This is, what's going on. So even for instance, at mediation, most of our clients are nervous to even talk during mediation, and they will ask that we talk on their behalf because they just have no idea what to expect at a mediation, even if I kind of explain the background. And so it really kind of helps even out that playing field for them to have someone in their corner, because ultimately OHR is a neutral party to the complaint. And so having an advocate there to talk them through and provide that support, I think makes it easier for them to navigate the complaint process, but it's still just incredibly difficult given the amount of time that the process takes. So talk to me about your concerns around a fact-finding conference, and how does that work, and what makes it potentially draining for a client? Yeah, so currently during an investigation, the individual reporting housing discrimination and the folks being reported for discrimination are interviewed at separate times, right? They submit their evidence at separate times. They don't interact with each other. The only face-to-face interaction that a client has with the person they filed the complaint against is during mediation. And frequently, due to that power imbalance, clients are asking that we talk on their behalf because they're so just nervous and unsure of what's going on. But during a fact-finding conference, the investigator, either through like a virtual format like Zoom or actually in person, has all parties in the conversation. And it results in a really high stress environment where clients are being asked to relive an extremely traumatic experience with the person on the line who did it to them. And potentially, hear some really hurtful things from the person the housing provider who is essentially trying to defend themselves from a discrimination claim, and may say all sorts of things during that call. And it's extremely difficult to remain in a state where you can clearly articulate what happened, when it happened, and all of that while you're potentially at like a housing provider is saying who knows what about you. And so like in that environment, it just puts people on edge, and it makes it really difficult, right? Especially if you're reporting things like harassment.
having the person who harassed you in that setting is just terrible.
Yeah. It's kind of being like re-victimized.
And so the current process of interviewing everyone separately, like, I think is just much more trauma informed, and allows people the chance to articulate their experience without having someone on the line who is directly interested in them becoming like, in trying to point out any potential, like to turn their words against them.
That makes sense. Thank you. I appreciate you taking the time to walk me through all of that.
Yeah, thank you so much.
Absolutely. So let's talk with Alana Eichner and Erica Sklar. So we are working to implement now, right? So, and thank you for your testimony. I think we've got some good tasks to take on here. I'll talk with the director. Alana had raised, I think she must have had to go, the issuing guidance, which we are all watching for, and then also language access to that guidance. Anything else that we need to lift up with the director today on the Domestic Workers Act?
Yeah, Alana was sorry she had to step off, but I'll say just a couple of things. Yeah, language access is critically important for workers. And I think this may be a larger issue than just one department, but I think making things really easily accessible and easy to find is really helpful. In particular, having some really good landing pages with available links, especially when you have more than one city department that are administering different parts of the policy. It can be really hard to find information. And I think for both employers and for workers, being able to easily access information is critical. Lauren and Sophia, you may have other thoughts about that as well.
I agree with what Erica mentioned. It would only add outreach to both the domestic workers and employers, as this is a new, we're in somewhat of a unique situation where it's a whole category of workers that are now covered by the DC Human Rights Act, but also employers and people that don't often think about themselves as employers. So it's a particularly important public education piece because of that unique aspect of this work.
Okay. Very helpful. Thank you. We're, definitely going to want to stay on implementing all the new laws that are going into effect under our new jurisdiction. So looking forward to working with all of you as partners. Please feel free to reach out anytime as you're seeing things in motion, and think we can be helpful in getting things done right. Let's see. Lauren Corey also brought up delays. And I'm curious about the pilot from 2019 that you mentioned and what worked about it. So we can ask more questions about that. And then I want to also talk about the administrative dismissals that you've been observing, if you don't mind.
Yeah. So the pilot program, I believe, came as a result of community discussions with OHR about accepting charges in a way that was more efficient when complainant had an attorney, had drafted the charge in a way that they were comfortable with, and could essentially take out that extra step of needing to schedule an intake interview and then OHR staff drafting a charge for review, which in our experience had led to multiple rounds of edits and added significant time. I thought the pilot program worked well in the sense that, because it was a program and because it had guidance, OHR gave the community very specific feedback on the type of structure they were looking for in the complaints, so that folks could try to adapt what they were putting into a charge to what OHR was looking for. And I think, I believe from testimony after the pilot program that there really wasn't, the period of time in which it was launched didn't result in having that many charges filed under it because it wasn't, I mean, I think it was for a series of weeks. So I don't know if actually in implementation there was enough charges filed to say one way or the other whether it was an effective way of doing it. But I do think that OHR communicating to the community what exactly they're looking for, and if they have a particular structure that they want charges to take, is something that would be helpful, because then we can attempt to conform to the structure that they're looking to have the charges in.
Okay. Great. We can, maybe we can help get everybody together on that.
Yeah.
Okay. I think that would be a good action item. Okay. So you talked about administrative dismissals. You talked about a particular sexual harassment case. I mean, what was the follow-up on that? I mean, what was the rationale that you got back?
So in that circumstance, which is before it happened more than once, and then I understand it happened recently, the complainant filed a charge. It was a hostile work environment complaint that had happened over a number of years. And the one of the incidences was within the 1 year statute of limitations period under the DCHRA, but multiple other instances had happened years before, so weren't within the 1 year period.
So the one thing was able to be considered.
Well, so the law says that when you have a hostile work environment, it's the actual hostile work environment is one action. So if it happened over 5 years, if it happened over 1 year, it's all of the incidences taken together that make a hostile work environment claim. So if one of those has happened within the last year, it is timely.
Okay.
So when this happened in this circumstance, and then I understand recently, the person filed an intake complaint. They had their intake interview, and then OHR, when they issue administrative dismissals, they aren't making a finding, but they're saying essentially you didn't meet the bare minimum requirement for us to open an investigation. So in those circumstances where they had a lawyer, the attorney sent a letter back saying, citing the DC Court of Appeals case law that says that's not correct. And they have, in both circumstances, reopened the complaint and then started an investigation, or, docketed for investigation. So the concern is that one, that it happens even after having raised the issue, but also that a bigger concern about pro se litigants who might be coming to the Office of Human Rights without an attorney and don't understand that that's something that they could push back on. And once a case has been administratively dismissed, tolling starts again. So, it's tolled when it's with the Office of Human Rights, but once it's dismissed, it's not. So then they'd be in a place of needing to look to go to court, and or not understanding that they actually do have a legal claim that's, something that they could be pursuing.
So one thing that I'll ask OHR about today, and since they're here, maybe they'll have a chance to look this up before they give testimony today, is how many administrative dismissals have they done, let's say in the last fiscal year? How many of them were pro se? And how many of them had legal representation? And then of those who had legal representation in particular, how many were ultimately overturned? Because that's the kind of information that I think can help it, illuminate whether or not these are being done accurately, or, that's very helpful. Thank you for walking me through that.
Yeah, and that information would be helpful, because at least when, I'm sure people would have something to say about the investigation process, but at least with an administrative dismissal, it's sort of that first level of review. And so, if OHR reaches a finding of no discrimination, or that there's no legal claim after having gone through that investigation, there's at least been that engagement with an individual who's experienced discrimination to work with OHR on their complaint. The concern about an administrative dismissal is that it cuts it off so early that that folks without an attorneys might not know that they have an avenue to pursue their claims other than what has been presented to them at OHR.
Okay, that makes sense. Thank you.
Can I just add one thing about the question you had asked, Sophia, about the pregnant workers?
Yeah. Great.
So, and I'm sure if this is not the case, the director will correct me, but I believe right now there should be no operational concern about incorporating the pregnant workers protection into the DC Human Rights Act, because although it was originally passed under DOES's purview, I believe that OHR is investigating these claims already. So it's already part of the work that they're doing. So, if it were to be incorporated into the DC Human Rights Act, it shouldn't add an additional responsibility to OHR's workload. But right now, because it's a standalone, it doesn't have the benefit of DCHRA's enforcement structure, which includes, the remedies that Sophia mentioned, but also the DCHRA itself has several protections for pregnant workers that, relate to these claims. So I think practically they're already being heard and addressed by the same agency and in a similar fashion, but for those particular parts of pregnant worker protections, it doesn't have the remedies of the DCHRA. It doesn't have the same structure. So if anything, I think it would be more efficient to have them to have it all be part of the same law and enforcement structure.
So effectively, they end up going through almost the same process. They just can't get the results that others can.
Yes. So because it was passed as this standalone bill, it doesn't have the definitions of the DCHRA. It doesn't have the enforcement structure of the DCHRA. It's sort of just this standalone accommodation and other pregnant worker protections, but it just isn't. It doesn't have the benefit of the other sort of context of the DCHRA right now. But it is practically, it's being heard together and addressed together.
So interesting. I have to go back and look at what year that was passed as a standalone, unless you know.
I think it was 2014, and at the time it came up under Council Member Vincent Orange, and I believe his committee had jurisdiction over DOES, which is why I think it was passed that way.
Interesting.
But practically, because it fits with the work that OHR has been doing. So I think since it's been passed, OHR has been handling those complaints.
Oh, okay. All right. Well, that is definitely something that, we were already going to look into, but this additional clarification is very helpful. Do you happen to know about other states and how they do it?
I can't say for sure. I think that in most states, my intuition would be that they're heard together and that it's not a standalone bill, because typically, at least when we've been advocating for changes in the law in other jurisdictions, we're asking for additional protections in the structure that is already there for the human rights law, which would, I think makes sense. I'm not aware of a state that has a standalone law, but if it does, I think that the standalone law came with some of the things you would expect to see, like remedies, a definition, a statute of limitations, other types of, some would argue, necessary parts to the law. And here the pregnant workers bill is literally just the protections. It doesn't have those additional guiding elements for enforcement.
Great. Thank you for that. Appreciate it. And then I just want to check in with Reginald Black. Thank you for your testimony. And I definitely want to talk more with the director about homelessness as a protected trait and just see, what complaints they've gotten about that thus far. Have you worked with anybody who has filed a complaint so far?
So far with the new definition, no.
Okay.
And this is the kind of data we want. I did attend their training in which they have the new liaisons, and they talked briefly about the bill being in play and in law, but we still don't know what has happened since the bill has passed. And when we were looking at, the proposal to even, make this happen years ago, we saw that cases that implied homelessness at the time, which would have been personal appearance, there were only 9 of them.
Right.
And so we want to make sure that when these cases are brought, that they are properly investigated and categorized properly. And we would like to see, just what is that level of escalation? Like, can they solve some of them through mediation, or are people having to file lawsuits? And like, are there potentials to create funding streams for training and different things for both OHR itself and possibly something to help out our unhoused neighbors with that money? So we would love to see more data as they have, but we also need to make sure that we're also training staff in how to assist with the intake process. And it's especially acute for like social services, because so many women, like, that's where they perceive discrimination coming from at about 56% of the time. And it's the same for medical services. So we need people who can, if they ask for a supervisor or a manager, they're aware of the human rights complaint process. They can assist to fill it out. And then if there are adjacent documentations, like maybe with a case with MPD, you would attach the police report, bar notice, or whatever document was issued to the complainant at that time. So these are things we want to see, and we hope to get more information as to what has been done thus far.
Great. We'll dig in on that. Thank you so much for taking the time to testify. Thank you to this whole panel. Great panel. Really appreciated the dialogue. So now we are going to be joined by our government witnesses, including Chair of the Human Rights Commission, Motoko Ozawa, and Director of the Office of Human Rights, Nin Kane. So we'll have you both come up and take the oath, and then I know we have some scheduling conflicts, so you can go in whichever order you prefer with your testimony. Let's get you squared away, and then we will do it. Hi, Director.
Good morning.
Madam, hi. Madam Chair, do you also wish to take your oath now and get it over with?
Yes, please. Thank you. I'm just fiddling with my video. Sorry.
No, it's no problem. We're ready when you are, but you take
And
your time.
Chairperson, I've got a few people on staff who may be speakers later on. Would you like them to come on board now and get sworn in as well?
Yeah, let's go ahead and do that, and that way we don't have to worry about it later. Thank you. So let us know, who should we be promoting?
I believe your staffer has our list, but
Okay.
it will be Andrea Goblerud, Ayana Lee, Adrena Dean, who, although I think she has to leave early, but she has Elizabeth. I think that's about it.
We'll get them all promoted. Hi, Judge Pearson. How are you?
Fine, thank you. How are you?
Fine, thank you. Okay, see Andrea. All right, give us a second. It's a little bit of logistics here. Adrena's here now. All right, you said a couple other names. I'm not sure I'm seeing them.
Ayana Lee.
Ayana, okay.
And Adrena, what was Elizabeth's last name?
Let's see, Elizabeth. She might not be in the Zoom.
She's not on the Zoom. I can send her the link for her to join. I think she's on through the website, not through the Zoom.
Okay. Well, we can go ahead, and then when she joins, we can add her. So,
okay.
All right. So anyone who may be responding to questions or giving testimony, if you could unmute yourself, raise your right hand. Wonderful. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Great, thanks, everyone. All right. Now, Director or Madam Chair, whichever order you'd like to go, you may begin your testimony.
I think the chair will go first if that's okay.
Thank you very much. I will. Good morning, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. My name is Motoko Aizawa, and I serve as the chair of the District of Columbia's Commission on Human Rights. Thank you for inviting me to discuss the activities and accomplishments of the Commission in fiscal year 2022 and fiscal year 2023 to date. The Commission is an administrative body that is affiliated with the Office of Human Rights, or the OHR, but it is quasi-independent. The Commission's primary role is to adjudicate cases under the DC Human Rights Act. For this purpose, the Commission consists of up to 15 commissioners who are appointed by the mayor and confirmed by the DC Council, and administrative law judges, or ALJs, who are employed by the OHR. Currently, there are 12 commissioners and 3 vacancies. Recently, the Commission interviewed several candidates for the vacancies selected from applications received by the Mayor's Office of Talent and Appointments, and we expect a full roster of 15 commissioners following the confirmation process. As you know, the OHR and the Commission provide administrative relief for violations of civil rights laws that occur in the district. This begins with a complaint, which is mediated, investigated, and if applicable, conciliated by the OHR. There are 2 types of cases: public sector cases, which are filed against the DC government, and private sector cases filed against non-government entities. The former cases are adjudicated by the ALJs, whereas in the latter cases, if the OHR finds probable cause for discrimination following investigation and conciliation has failed, the case is certified for a public hearing on the merits before the Commission. The Commission is currently supported by 2 ALJs, with Chief ALJ Erica Pearson directing the day-to-day activities and responsible for tracking and managing the Commission's caseload docket. They preside over Private Sector Human Rights Act cases as well as ban-the-box cases once they have been certified by the OHR for a hearing. Before proceeding to full evidentiary hearing, the ALJs issue a scheduling order under which the parties are allowed to exchange discovery, and motions for summary judgment are considered after discovery has concluded. The presiding ALJ then conducts a full hearing, much like a trial, in which the parties are afforded opportunities to present their evidence, including witnesses. Once the full hearing is completed, the ALJ assigned to the case requests a tribunal of 3 commissioners to review the case and the final order prepared by the ALJ. The tribunal then meets to discuss the case and either adopts, amends, or rejects the order proposed by the ALJ. Once the decision is finalized, it is issued to the parties. The Commission meets bi-monthly to be briefed on developments, including status reports on cases pending with the Commission, updates from the OHR and various committees, and any other activities undertaken by the Commission. We frequently invite guest speakers and periodically receive training to stay updated on community initiatives, as well as changes in relevant DC laws and regulations. In addition to forming tribunals to help adjudicate cases under the DC Human Rights Act, the Commission has another important mission to help raise people's awareness of the benefits of the DC Human Rights Act. I will now turn to our key achievements from FY22 and FY23 to date. First and foremost, we made steady progress in addressing both the backlogged cases as well as new ones. Altogether, the Commission successfully closed 13 cases in FY22. Of these, 4 cases were certified more than 15 months prior to closure, whereas 9 cases were closed within 15 months of certification. In FY 23 to date, 2 of the oldest cases that were certified in 2018 and 2015 respectively remain. These cases were delayed due to the unique circumstances related to the parties. Both cases will be closed in FY 23. Of the 3 cases that have been closed in 2023 to date, all were closed within 15 months of certification. Several enhancements have contributed to the Commission's efficient resolution of cases. We moved a rotational system to form tribunals instead of commissioners relying on commissioners to volunteer to serve on tribunals. The ALJs offered alternative dispute resolution in all cases and held approximately 10 settlement conferences. This resulted in a settlement rate of 75%. In addition, the ALJs completed and published a discovery manual as well as a set of fillable forms. Both of these resources are intended to aid pro se complainants in bringing complaints. Furthermore, many of the glitches that existed in the case management system have been corrected, making commission cases more easily accessible by all parties to a complaint. In spite of the foregoing improvements and achievements, the Commission believes that the current 15-month time frame from certification to closure is not suitable for complex cases and proposes that the more realistic time frame should be 20 months from certification to closure. The Commission's Rules Committee, Awards Committee, and the new Outreach Committee have been active on emergency amendment of sections 401 and 408 of 4 District of Columbia municipal regulations regarding representation were finalized in FY 22. Under the leadership of the Awards Committee and the Outreach Committee, the Commission successfully held its in-person annual Human Rights Awards Gala in December 2022 in close collaboration with OHR. With over 110 people in attendance, Lauren Taylor of Defend Yourself received the Cornelius R. Neal Alexander Humanitarian Award, and the Emerging Leader Award went to 3 young awardees, David Burek, Taylor Dumpson, and Addison Rose. Reflecting our discussions from the 2021 Gala, we created a community awards this year. It was awarded to the Atlas Performing Arts Center City at Peace program. For the first time in our history, nominations were received from community members in addition to the Commission. The event inspired us to redouble our efforts on community outreach, especially towards youth. In FY 22, the Commission prepared to catalog our past Commission cases beyond the more recent cases that are posted on OHR website since 2020. This project would allow Commission precedents to be organized and accessible and enable analysis of case trends over a longer period of time. After some stock taking, the Commission found that the past decisions had not been digitized, and the paper files of these past cases were sent to an archival service for storage. As a result, in FY 23, the Commission aims to focus on digitization of past cases with the help of a dedicated law clerk. Moving on to our priorities for FY 23, the Commission has identified the following 5 areas to prioritize in the current fiscal year. Our first priority continues to be moving cases efficiently from certification to closure. 22 cases are pending before the Commission as of February 7, 2023. Of these, we will pay special attention to close the 2 oldest and most complicated cases and aim to close new cases within 20 months from certification to closure. The ALJ will continue to offer dispute resolution to all parties. This fiscal year, the Commission may move to a new case management system, one that will be common with the OHR if they obtain a new system. Regardless of such move, the Commission intends to ensure a smooth operation of the system throughout the fiscal year. Our second priority is to make it easier for unrepresented litigants to bring complaints. The priority will be implemented by the ALJ through improvements in the discovery process, as well as rule changes to make certain rules clear to complainants, especially those who are self-represented. Third, the Commission will continue to collaborate with OHR to revise the procedural rules in Chapter 4 of the DC Municipal Rules. More specifically, the FY23 work program spelled out by the new reconstituted Rules Committee centers around case dismissal as well as other confusing or outdated provisions. Fourth, in FY23, we will attempt to digitize the archived files, cases with the help of a dedicated OHR intern and make the fully digitized cases available to the public. Once this milestone is achieved, the Commission can propose a system to categorize past cases for ease of access and analysis. Finally, the Commission will continue to actively raise awareness for the human rights protections afforded by the DC Human Rights Act. We will participate in outreach activities organized by the OHR and plan to work with youth human rights ambassadors to reach out to and partner with youth organizations, and of course, organize yet another successful human rights gala, tentatively scheduled for December 7th of this year. And I must say, all of those who are on this Zoom channel, please join us. Now, I would like to turn to a couple of initiatives that the ALJs are undertaking. First, they will pilot the use of form discovery, which is case type specific pattern discovery to simplify the discovery process. Another initiative is to publish commission cases on the DC Register to make them available to the public and searchable on internet search engines. Many of these planned commission activities that I just described are made possible through the excellence, dedication, and persistence of the ALJs, for which the commissioners are deeply thankful. In closing, the Commission on Human Rights believes its work has a positive impact on the quality of life of DC residents. We are already implementing our FY23 priorities and look forward to a close collaboration with the OHR on the promotion and advancement of the district non-discrimination standards under the Human Rights Act. We appreciate the opportunity to share our accomplishments and plans for continuous improvement and look forward to continuing to work with all of you. I am available to answer any questions you have. Thank you.
Thank you so much for your testimony and all of your work. You noted that the status of the Commission's case management system with Synergy was becoming cost prohibitive to maintain on their servers. So the CMS is now maintained by Synergy, but migrated over to Octo servers. Has Octo offered any alternatives given how expensive that is?
Yes, we have been going back and forth with Octo on this issue, but I will request Chief Judge Pearson to perhaps clarify and provide the details.
Thank you.
Sure, yes. Excuse me, Octo migrated the system to their servers at no cost to us, but they have still deferred to Synergy to really maintain it. So Octo is not doing, for example, the security patches because it is a proprietary system from Synergy, so they don't really have the access that they would need to keep it updated stuff. So they host it, but Synergy still does the work on the system.
Okay. Understood. Been in that situation sort of before with some of our techs. So now the Commission creates committees to support the work it conducts, and I thank you for that. In your pre-hearing answers, you noted that the procedural rules in Chapter 4 of the DC Municipal Regs were revised in FY22. Could you briefly cover for us what changed and whether the Commission is planning to revise or amend any of the other rules?
Thank you for that question. I will just provide a brief overview. for FY22, we and the previous fiscal year as well, we worked to address certain confusing issues that arose in connection with OHR's presence in the case. They are present in our cases representing the complaint, as opposed to the complainant, who must have either their own attorneys or they are self-represented. But in some cases, the complainants assumed that OHR is there to represent their case. And so in order to clarify this, we had to amend the language of the municipal rules. Going forward, there are also similar language that confuses the process in terms of when cases may be dismissed, even when the parties may be agreeable to dismissal. And so we would like to provide clarity in this. And this is to basically ensure that once the parties are clear that they are agreeable to dismissal, that the case doesn't drag on unnecessarily and use up a lot of resources. And I'm just going to look very quickly to Judge Pearson to see if she would like to supplement me.
Right. So the Rules Committee has been actively meeting, and we're also working with the Office of General Counsel at OHR. So we do plan to do some comprehensive amendments to the procedural rules this year jointly between the Commission and OHR.
Chairperson, you are silent.
Thank you. When you say this year, what is the timeline you're thinking of?
Well, we have some emergency rulemaking that particularly dealing with the issue that Chair Aizawa mentioned with some confusion about dismissals. So that's already in draft form. It's being reviewed now by OHR, and we do have to then send it over to Office of Legal Counsel for review, but we expect to be able to have that done in the next 30 days. And then I think for the full overhaul, our goal would be by the end of this fiscal year for the whole chapter, particularly it's chapter 4 of the DCMR.
And that includes drafting and all that review?
Yes.
Okay. Thank you. One of the priorities you indicated for FY22 was moving cases efficiently from certification to closure, which it has taken more than 15 months to do in some cases. Did the Commission meet its goal to decrease the length of time it takes to reach closure?
So as I stated, the Commission has been trying to meet the 15 months goal that it has and found that on average, we are able to meet or better that framework. But in some very, very rare cases where the circumstances of the cases are so difficult, as you can imagine, for example, when we have a incarcerated complainant, that's just one example I am aware of. When things get complicated like that, it is not possible for us to stay within the 15 months time frame. And therefore, our proposal is to move that time frame from the 15 months period that we have to 20, while still aiming to move cases expeditiously through the various improvements that we have mentioned to you.
Are there specific types of cases you have in mind that you think it is more appropriate to hit a 20-month benchmark? You mentioned if a complainant is incarcerated. Are there other situations?
It depends on the complaint. So it's just then the more complicated complaints require lengthier discovery periods, and it takes longer. But then there's other cases such as, cases that come under the Fair Criminal Record Screening Act the criminal background check for the protection of children, those cases should be resolved very quickly and shouldn't, less than the 15th month. So one of the things, for example, we've talked about is assigning a track to the type of case, so that, for example, if you're a track 1 case, then you would expect the resolution to be within perhaps 12 months, and a track 2 case would be perhaps 18 months. So we would designate by the allegation and the complexity of the particular case.
Okay. Is there additional staff that was added to get to the 15-month goal?
We do have a full-time law clerk this year. We have not had any law clerk or support staff for the last 2 years, in part because we weren't able to recruit, not necessarily because there wasn't funding, but because of the relationship that we go through a fellowship with Georgetown. We just sometimes weren't successful with getting a fellow. So having a full-time fellow this year has made a huge difference for us in being able to process the cases. And so the Director Kind has committed, going forward, we will always be able to have a full-time law clerk. And if we aren't able to recruit someone through the fellowship, then we'll recruit outside of the fellowship.
Thank you. What's the benefit of having a fellow versus a regular FTE in that position?
Well, the fellow is a FTE. They are hired as a full-time DC government employee, but the only difference is through the partnership, Georgetown is paying for half of the salary.
I see. Do you think it would be preferred to have more funding so that you would have less turnover?
Yeah, we've definitely had that conversation that it would be nice to not have to hire a new person every single year and train them and get them on board. So having, and whether it's a paralegal or a law clerk.
Mm-hmm.
I cannot agree more.
Okay, it's picking up on that. Okay, well, let's talk about that later, but it's on my list. So one of the commission's priorities is to make it easier for unrepresented litigants to bring complaints. We talked about this a bit in testimony. As we heard from public witnesses, the adjudication process is challenging and time-consuming for individuals to navigate, especially the discovery process. Can you talk more, expand on what you're talking about and planning to make the process easier for pro se litigants?
Yeah, so particularly for pro se litigants, when it comes to discovery, it's really difficult for them to put in discovery requests, to come up with interrogatories or requests for production on their own. So based on the particular allegations in the case, we would have that as a set questions already for them to submit. So it would be more of automatic disclosures. And so we would have the questions, if the complaint, for example, is race discrimination, then we would already have prepared a form of standard interrogatory questions that the opposing side would have to respond to, and then it takes the burden off of the complainant to have to come up with questions to get the information that they need to meet their burden.
That is so simple and helpful.
And I would just like to add that the ALJs also have come up with a litigation manual for litigants, and I think that also is another resource.
Mm-hmm. Does the litigation manual guide complainants on their rights and how a letter of determination impacts them?
It doesn't really address the letter of determination because it's dealing more with the litigation aspect. So the letter of determination is what brings the case to us, and so we're really with what happens after the letter of determination is issued.
I see. Okay. One thing, just the reason I'm asking is, what do we know if complainants, pro se complainants, understand how a letter of determination affects their rights outside this process, and if that's something that we should be informing them about?
Yeah, I think there's definitely confusion sometimes, particularly in those situations where they might also have received a letter to a right to sue letter from EOC, and then wondering whether or not they can still file their complaint in federal court. And so, yeah, there's definitely confusion, but also being that this is an administrative process, one of the benefits is that they have more access to the ALJs than you would have if you were in like a traditional superior court. So, they'll email us and ask us the questions and we'll answer them. So we do have a lot of just back and forth with the litigants in a way that you don't normally see in a more traditional court setting.
That makes sense. Okay. Anything you want to add before we wrap up?
No, nothing for me.
I just want to respond to the comment that Mr. Syndrome raised, that he had not been able to join our bi-monthly meetings. In fact, our meetings are open and have been open despite COVID and everything else. And so if there's any difficulty in Mr. Syndrome accessing our meetings, we would like to know. I believe we post all the meeting notices as required, as well as our minutes and everything else. They are all open. And so I just wanted to note that we are open and accessible. Thank you.
Wonderful. Are those meetings, can one join by phone the way he joined the Zoom by phone?
Yes.
Yeah. Okay. Yeah, that is, I think, his primary accessibility issue is the computer access. So, okay, very good to know. We will certainly advise him. And I believe that he does access the DC register, and the meetings are there as well.
Yes, they are.
Okay. Thank you. It's always important for us to highlight the ways that we reach people when they don't have access to all of the technology. So thank you for clarifying that.
And we also live stream it on YouTube.
Okay, very good. That is all I have for you. Thank you very much for your testimony. And we will now hear from our director, Nin Kine. And you've already done your oath. I know Elizabeth joined. Should we just swear her in real quick and then keep it moving? Yeah, let's do that. So Elizabeth Holst, if you could turn on your camera, unmute yourself, raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Great, thank you. All right, Director Kine, you may begin your testimony.
Thank you, Chairperson. Good morning, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. I'm Nin Kine, Director of the District of Columbia's Office of Human Rights. Thank you so much for inviting me to discuss the activities and accomplishments of OHR in fiscal year 2022 and 2023 to date. OHR, as you know, works to eradicate discrimination, increase equal opportunity, and protect the human rights of individuals in employment, housing, education, public accommodation, and government services. We achieve this in two ways. First, by educating our communities, and second, by enforcing local and federal civil rights laws through a cost-free legal process to those who believe they have experienced discrimination. In broad strokes, our enforcement process is a two-part process in which we begin with an investigation, and should we find probable cause to believe discrimination may have occurred, we certify the case for a public hearing. The Commission on Human Rights assists with the second part of our process by assigning a tribunal of commissioners to help render a final decision after an assigned administrative law judge has held the hearing and has submitted a proposed decision. With respect to our education responsibilities, these functions have grown and expanded significantly over the last few years. To provide a sense of the agency's broad jurisdiction, I want to highlight the laws we enforce. Chief among the laws, of course, is the District's Human Rights Act of 1977, which as of this past October prohibits discrimination based on 23 protected traits, making it one of the most progressive and inclusive protections in the nation. Other laws include the DC FMLA, the DC Parental Leave Act, the Fair Criminal Record Screening Amendment Act, better known as Ban the Box or FCRSA, the Fair Criminal Record Screening for Housing Act, the Protecting Pregnant Workers Fairness Act, the Unemployed Anti-Discrimination Act, the Employment Protections for Victims of Domestic Violence, Sexual Offenses, Stalking Amendment Act, and the Anti-Retaliation Provisions of the Universal Paid Leave Amendment Act. Finally, OHR enforces a number of equity and compliance laws like the DC Language Access Act, the Youth Bullying Prevention Act, and new in the last couple of years, parts of the Tipped Wage Workers Fairness Act, the Racial Equity Achieves Results Act, and the Care for LGBTQ Seniors and Seniors with HIV Amendment Act. In FY23, OHR is enforcing two additional new laws, the Human Rights Enhancement Amendment Act and the Eviction Record Sealing Amendment Act. Working with our federal partners, like the U.S. Equal Employment Opportunity Commission and the Department of Housing and Urban Development, OHR helps to enforce Titles 7 and 8 of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. All in all, OHR enforces approximately 20 different human rights and employment laws in the district. I will now turn to OHR's key achievements, starting with our operational developments, the impact of those developments in our enforcement work, and then continue to programmatic accomplishments and community engagement efforts. FY22 was a year of growth, rebuilding, and transitions for OHR. The agency, by all accounts, was a very small agency with only 30 to 40 FTEs from 2015 to 2018. However, from FY15 to 17, OHR saw its biggest caseload growth as its docket doubled and received on average 566 new cases per year. Without growth in staffing levels to match this, OHR's case processing rate began to lag. It was not until FY20 and 21 that OHR was able to finally expand in its operational size. Due to a number of new laws added to OHR's enforcement portfolio, the agency saw a large growth in approved FTEs between FY19 and FY21. However, as a result of the pandemic and leadership transitions at OHR, the agency was not able to fully realize the growth by filling all of these positions. These challenges continued into FY22 as OHR lost the director, general counsel, and a senior attorney advisor. Nevertheless, as the world reopened in FY22, thanks to the support of the mayor, the deputy mayor, and DCHR, OHR was able to work tirelessly to fill its open positions. And I'm so proud to share that by the end of FY22, OHR's workforce increased by 40% as we filled 20 new positions. Filling these positions allowed OHR to add investigators to our enforcement teams, establish a new fourth special assignment team to focus solely on our older cases, and expand the office of the general counsel. Though this is just the beginning of OHR's growth and expansion, our accomplishments have already brought positive change for the agency. For example, the addition of staff resulted in reducing the caseload for investigators and therefore a morale boost. Restructuring and expanding the Office of the General Counsel meant OHR was able to provide dedicated legal advice and counsel to each of the enforcement teams, conduct more legal sufficiency reviews on things like the agency decisions, enforcement guidance documents, training materials, and much, much more. With these concerted efforts, by the end of Q4 of last year, OHR doubled its case processing rate and saw a reduction in our inventory of aged cases. I will discuss more on this point later in the testimony. Growth in staffing, of course, means an increase in operational and management needs. Therefore, OHR worked to modify its existing organizational structure to include an additional tier of management. These new senior leadership positions are designed to oversee the different units within the agency and are as follows: Chief Administrative Officer, Senior Advisor to the Director, Associate Director for Enforcement, Associate Director for Communication and Education, and Associate Director for Compliance and Equity Programs. Finally, as OHR has nearly doubled in size since 2019, we're working closely with DGS to identify a consolidated workspace for OHR's entire staff. I will now transition to discussing OHR's enforcement work. OHR's enforcement unit is made up of 4 investigation teams, as opposed to 3 last year, and a team of 3 mediators. These teams are supported by attorney advisors from OHR's OGC, and the hearings are held by our ALJ and OHR's recent mission, which resulted in a per investigator caseload reduction from over 40 to now 25. That's a 37.5% reduction compared to FY21, and even greater reduction when we compare it to prior years when an average caseload was 60 to 70 cases per person. This helped to meet our FY22 goal of completing investigations in 50% of our cases that were backlogged at the start of the fiscal year. Similarly, for the first time in OHR's history, with dedicated attorney staffing, we were able to double our legal review in Q4. Now, to provide all of this in a little bit more context, in FY22, OHR received 1,090 initial complaints. We processed 977 cases, docketed 361 charges of discrimination, mediated 327 cases, of which 132 settled and resulted in over $1.17 million in payments to complainants. And we closed approximately 368 cases. Through the hearing process, our ALJs closed a total of 17 cases, with a total of $503,000 in recovery for complainants. As compared to FY21, though OHR received about the same amount of cases, OHR closed approximately 20% more cases in FY22. I'm proud to add that in FY22, despite our growing pains and transitions, the agency conducted 72% more intakes and successfully scheduled 89% of those intake interviews within 30 days. This success rate is higher than both FY21 and FY20. Additionally, by the end of the fiscal year, our ALJs were able to close more cases in FY22 with only 20% of cases pending longer than 15 months. Through the dedicated efforts of our language access director, we were also able to provide initial intervention in those cases within 30 days, 100% of the times. On our programmatic side, we also had many successes there as well, thanks to our team of dedicated managers and staff. After a bit of a gap, OHR successfully onboarded a new youth bullying prevention manager in later half of FY22. And in his short time at OHR, together we were able to rebuild our connections with schools, parents, and other youth serving agencies. Indeed, our new partnership with the DC Public Libraries resulted in circulation of over 1,400 bullying tip sheets and another set of 1,400 parent bullying prevention brochures. These are available on our website as well as DCPL's website. Along those lines, I'm so pleased to share that overall, OHR provided support to the community in FY22 more than ever as compared to prior years. For example, we held a total of 59 general education and outreach events. We trained 143 human rights liaisons, which is almost triple the amount of the 47 folks we trained in FY21. We conducted 14 youth bullying prevention education and outreach activities, which is a tremendous improvement over the previous 3 years of having just a few activities each year. We also held 72 language access trainings for our covered entities, and thanks to our very dedicated team player staff, OHR was able to train and certify 104 EEO counselors and officers despite losing our trainer mid-year. I want to add that in response to our community's needs, during the pandemic recovery period, OHR added a new initiative to include monitoring websites and providing technical assistance to mitigate gaps in language access services during our most dire of times. Most significantly, we listened to our residents through the reestablishment of our listening labs. which connects residents with services in the district, whether at OHR or elsewhere in the government. Also in FY22, pursuant to the Racial Equity Achieves Results Act, we worked with the Mayor's Office on Racial Equity to develop training materials, including a guide on using inclusive language in the district. Within our newly created Safer Spaces program, OHR worked to reach many milestones under the Tip Wage Workers Fairness Act. This law requires businesses to, among other things, provide sexual harassment training, report compliance to OHR, as well as the number of sexual harassment complaints to OHR. OHR in turn is to educate the community, certify trainers, and build an online portal for submission of information from businesses. I'm proud to report that under the leadership of our passionate program manager, we launched our Train the Trainer program and connected with hundreds of businesses on preventing sexual harassment in the tip wage industry. We conducted the Train the Trainer presentations that included Saturdays to accommodate our audience, and which resulted in approximately 40 certified trainers to date. We also produced written guidance, training materials, and several outreach documents, and regularly met with community stakeholders, including the Tipped Wage Council. Through the tenacity of our manager, we also successfully launched an online portal for businesses within the first month. We received over 150 sexual harassment policies from businesses, which we review for compliance. Similarly, in compliance with the Care for LGBTQ and HIV+ Seniors Act, which makes it unlawful for long-term care facilities to discriminate against individuals because of actual or perceived sexual orientation, gender identity or expression, or HIV status, OHR Safer Spaces program has successfully developed the training content for this program, and I'm happy to tell you that we're going to be launching our first Train the Trainer course in mid-February, shortly following this hearing. In FY23, several amendments to the DC Human Rights Act went into effect. Top line changes include adding homeless status as a protected trait across all enforcement areas, and substantially redefining and expanding the legal definition of what constitutes harassment. OHR also began enforcing the newly enacted Evictions Records Sealing Act, which strengthens source of income discrimination protection through explicit statutory language. To educate our communities about these new laws, OHR swiftly drafted and published guidance documents, followed by trainings for employees, the Commission on Human Rights, the public, and legal practitioners. In FY23, we're launching a number of business outreach activities that will again touch on these new laws. As we proceed in FY23, OHR has several priorities as follows. 1, case processing improvements and related public information. 2, case management system and IT system investment. 3, investing in our people. 4, operational growth. And 5, of course, finding a new home for our growing agency. With regard to case processing, we are working on improving timelines by implementing a multi-pronged solution. While OHR was successful in FY22 in closing a number of older cases, our new cases started to age as our focus was on older cases. To close this gap, OHR will dedicate specific teams to work on the following 3 categories of cases: A, older cases; B, existing cases; and C, new cases. Second, OHR is re-examining its case processing procedures to create more efficiency in claim reviews. Third, we will launch a fully working case management system to assist with case processing and data analyses. To that end, we've been meeting with various software developers, including those at Octo, and we expect to hire an IT specialist later in this quarter to manage this project, as well as to provide for the growing need for day-to-day IT support. Finally, as we have fully operational case management system, OHR will provide case-related data on our website for public consumption. Next, in order to invest in our people, OHR is working on a number of employee programs, such as incentive awards, career ladders, and employee recognition programs. I'm thrilled to report our first incentive award committee is already underway. Finally, as OHR continues to grow, OHR will expand the operations team, which currently exists of only 2 FTEs to support an agency of 80 FTEs who also wears so many hats within the agency. And to house our growing agency, we're of course working closely with DGS to identify a new space. In closing, I'd like to thank the passionate and hardworking team at OHR. OHR is only successful because of its dedicated team. I'm so proud of the work that we do. I'm thankful to work alongside such dedicated professionals each and every day. I'd also like to thank you, Chairperson Nadeau, and the Council for always being champions of human rights in the district. I look forward to your leadership and support for the work of OHR under this new committee. We certainly appreciate the opportunity to share accomplishments and plans for continuous improvement and look forward to continuing to work with you and the committee. This concludes my testimony, and I'm available to answer any questions you may have. I apologize that took a while, but we had a lot to share.
Thank you. Appreciate your testimony very much. Okay, so you have been here all morning, so you heard the public testimony as well. Let's start by talking about what we heard from the public witnesses. The first testimony we heard was about protecting pregnant workers. Now, I noted in your testimony, you already do work protecting pregnant workers, but it is not part of the Human Rights Act. The recommendation is to incorporate it rather than have it as a standalone law. What do you think about that operationally?
I think operationally that should be a fine transition. My only note here is that anytime we make these transitions or changes, as I'm sure you'd expect us to do, our legal team is going to have to vet this whole thing and spend some time to make sure we're not going to miss any gaps in the transition and combining PPWFA with HRA. So which, I note that to say it's the same legal team that reviews cases. So anytime that we're doing additional work beyond reviewing our complaints at OHR, it does take us away a little bit. But other than that, for the long-term transition, I don't see any operational impact at this time. But, we're happy to work with you, Chairperson, and your committee to see if there's anything else that we need to touch on.
Okay, that sounds good. Thank you. We can take that up later in the year, perhaps. You also mentioned the new protected traits. Homelessness in particular came up. Now, it sounded like from your testimony that you have issued guidance on that. Can you tell me more about what you've done?
Yeah, we've issued our guidance around what this means and the fact that, it covers all 4 enforcement areas. Oftentimes people believe that our work is only in employment or housing, for instance, and we want to make sure that they know that for something like homeless protection, it's so important to know that it's protected in other areas as well, like public accommodations when someone goes into a Starbucks or, to a restaurant, right? And that it's also covered in public education in school settings. And so we put out an enforcement guidance, and we're happy to share that with you, Chairperson, and the committee if you want to take a look at it. But we worked really hard to make sure that was published earlier in the last quarter.
Okay, and then how does that get disseminated to people who might need to utilize that?
Sure, we put it in our newsletters, it's on our website. We share it with our listserv. And so we also incorporate all of this information as we conduct more and more trainings. And I believe we just had an HRL, the Human Rights Liaison trainings, last month, if not, yes, last month in January. And so we would have incorporated that information into our trainings as well. As you know, we do a number of outreach events. And believe me when I tell you, every single time we go out to the public, we take the opportunity to do a plug on what OHR does and always the new laws that we enforce. And just as my professional development, I recently taught a DC Bar legal CLE, continuing legal education course, in which, of course, I spoke about this new addition as well, so that practitioners and folks representing businesses would understand, that this is a new law that's now in effect as of FY23.
And for this particular protected trait, has there been any consideration given to perhaps doing a briefing for the street outreach workers that serve our homeless residents?
I think that's a fantastic idea. I don't know if our communications and education team has considered that, but I will certainly connect with them to ensure that we're working in a targeted, tailored way.
Great. It's a pretty close-knit nonprofit community, and many of them are direct grantees of the government, so I don't think they should be so hard to access.
That's right.
The other guidance that we were asked about was for domestic workers and their employers. Can you talk about the process for them.
Yeah, so I'm so glad Councilmember White joined us this morning to provide some comments, because as I was preparing for this hearing, I looked into that bill, and as I understand it, it's going into effect March, but there is no funding in FY23. And as I heard Councilmember White say that you're looking to fund it for FY24. So as we've not received any funding, we've not done work on that yet. But our goal is always to make sure to get outreach materials out there, and we certainly talk about it as an upcoming protection, even when it's not been legal or effective. So as soon as we get funding, we'll jump on that, just like we did with the homelessness and the eviction record sealing this past quarter.
Okay, great. Let's see. Oh, so we still heard about some delays, and you probably took great interest in that testimony. So could you talk to me a bit about what you think is happening there?
Yeah, improving case processing timelines is always at the forefront and the top priority for me and our agency leaders. We're always looking to refine that. But I also want to caution that, there are exceptions to these rules, right? Just as our Chief ALJ was discussing about how complicated cases take more time at the hearing phase, it's the same thing is true for the investigative and even the intake process stage, is that the more complicated the case, when I say complicated, I mean both in terms of the legal concept, as well as in terms of the number of claims that we get. So on an average, we might get a complaint that has allegations of 3-4 protected trades and 2-3-4 legal theories. And so the more there is, the more we would have to investigate and look into and review. So, but the short answer is we're working on it. I think with the dedication of our special work assignment team, the SWAT team that I mentioned earlier in my testimony. And along with that, and the fact that we now are going to have dedicated teams working on each of the different types of cases, so that, sort of like no case gets left behind, we're going to see some progress, even more progress, I should say. We made some progress in FY22, more progress in FY23. Lastly, I'd say that, as I always encourage our advocates and community folks to come to my agency leaders to talk about issues they're having, and don't wait until the oversight hearing to bring up these issues, because we want to resolve them, right? And we also have quarterly meetings with community advocates, of which Susie from ERC is a part of those conversations. And so I'd also invite Mawila to come to those meetings so that they can be a part of that conversation as well. That's so that, OHR is keeping in touch with community members, and we're working together on how we can improve this. Because as I always say, it's not something that we can do alone. This job of eradicating discrimination and having a fair process, it's our job as a community to do it together.
Mm-hmm. Mm-hmm. Great, very helpful. I actually meant to ask about the homelessness as a protected trait. Do you know how many complaints have been filed under this trait yet?
We looked into that, and I don't think we have any right now, but we're obviously close, trying to keep an eye on that as a new protection, and so that we can report on that in the months and days to come.
Okay. And you heard the testimony about the fact-finding conferences, right?
Yes, that's something that ERC has mentioned in our community meetings that we've had before.
Mm-hmm.
And so, we're certainly going to see if we can make any sort of adjustments or modifications to our process to address that issue. But we are looking to speed up our case processing. And one way to do that is to get everyone at the table to talk about, the information that we need, rather than going back and forth, which can cause delays, which we don't want, because, when we say, okay, if you were a member of council, if you were a party to a litigation at our office, council member, we'd say, we need your answer in 20 days. And you might say, well, actually this came up and I need 30 more days. And so we'd always give people an extension for the first time. And then, the other party might say, well, I need another extension for me for 30 days, right? So the time just keeps getting added on and on and on. And so convening everybody together at the same time to ask just the vital necessary questions is really helpful. Mm-hmm. And by the way, we weren't suggesting that we would do this fact-finding conference for every single case. We would choose cases that are more susceptible to closing, more quickly, like our DC FMLA cases where it's, did you grant the leave or not?
Right.
It's
That was
simple.
going to be my next question, is maybe this lends itself better to certain circumstances.
Exactly.
Okay.
Exactly. We want to, the bottom line is we want to be thoughtful about it. We don't just want to roll things out without, being thoughtful.
We also talked about administrative dismissals, and I wanted to get some data from you, if not today, then after the hearing, about how many of those you see each year and what the circumstances are of pro se versus represented complainants.
So I don't know that we'd be able to give you the breakdown for pro se versus non-pro se, just because our system doesn't track it that way. And but certainly one that we're flagging for our improvement as we build a better functional case management system. But what I can tell you is that my data shows we had 618 dismissals in FY22. And so, but the dismissals are a combination of different types of dismissals. It isn't just the administrative dismissals that one of the witnesses mentioned this morning. So I don't want you to think it's 618, administrative convenience dismissals that was raised. It's just dismissals in total. So those dismissals, consist of where we don't have jurisdiction, we have to deny the case, or it doesn't state a claim, so we can't move it forward, or we dismiss it if another jurisdiction has it. So like if it's in court already, if the EEOC has it already, and that's the type of situation where the administrative convenience might come up. Cases where it's, despite our, as you heard, we take quite a long time to try to thoroughly get information from the party, from the complainant in doing intake. But if the information we obtain doesn't show that it states a claim, but it doesn't clearly show that it doesn't state a claim, we might dismiss the case and say, all right, this might be the kind of cases where you might have to file in court because we've done all the vetting we could at that beginning stage and it just doesn't clear. So those are the myriad of ways in which we might dismiss a case.
Helpful. And if there is any way to drill down on any of that data, even the type of dismissal, I'd really love to understand it better so I can be thinking that through and understanding just how it all works and sort of where the deficiencies might be in either supporting complainants, et cetera, in community, that sort of thing. I just want to make sure I'm not missing anything from public testimony before we transition to my prepared questions. Okay. I think I'm good on that, unless you remember anything you heard that you wanted to respond to.
Not at this time, I don't think, but if anything comes up towards the end before we wrap up, I will share it with you.
Okay. All right. In April of last year, your office requested to reprogram $600,000 from the personnel budget to address an ongoing case backlog by bringing on additional investigation support and providing training to OHR's enforcement teams. Based on the supporting documentation, the funds were available because the office could not fully fill some of its new positions, but planned to do so by the end of the fiscal year. Which positions were those that made up the vacancy savings, and have those positions now been filled?
So we'd have to get back to you with the specific positions, but I can tell you positions were filled. Like I said, we filled 20 positions last year and grew the agency there by 40%. But to give you those details, we certainly would have to get back to you and happy to.
Okay. You talked about in your testimony how you made progress on the backlog as a result of the reprogramming. And how many positions are currently vacant?
Currently, let's see, let me look at my little cheat sheet here about the number of vacancies. I think currently we have 13.5.
It's always funny to hear about the 0.5s.
I know, but it exists.
It does exist.
Because we get 0.5 FTEs from like a bill or something, so.
Yeah, you're welcome. So the office's pre-hearing response to the committee's inquiry on vacancies notes that there are 5 intra-district funded positions which are frozen. And that is half of the agency's total intra-district FTEs. Under what programs in the agency's org chart did these positions fall?
So there's not an org chart for those 5 frozen positions because those are the positions from UPL, the Universal Paid Leave Act, where we can't touch those. So they don't have a home right now because we can't touch them.
Okay. So that includes some ALJs?
No.
No, okay. And why are they frozen?
Because they have to be UPL related cases that we fund this for. And currently we maybe have 1 or 2 UPL cases.
Oh, I see. That would be a lot of board people.
Yes.
Okay.
And yes.
I got you. Okay. So the thinking is that you will fill those as cases ramp up?
Exactly.
And how do you monitor that so you're not too late?
We constantly check in with our team to see how many cases are we getting in this. And, we constantly do outreach to ensure it's not our shortcoming with respect to outreach on this, even though this law has been on the books for some time now. We constantly talk about Universal Paid Leave Act because, when it went into effect, it was COVID. And so, we want to make sure we treat it like it's one of our new laws and always, stress on that new protection.
Mm-hmm. Okay.
And we work, very closely with DOES on this.
Do you expect to see a request in the mayor's budget next month on the funding for the laws recently passed by the council?
Do you know which laws you might be referring to?
Well, we talked about the domestic employers, for example.
I see.
Yeah.
So I'm not sure. We'd have to think about that one because I just learned recently that was going to go into effect because of congressional review passage time in March. So we'd have to get back to you. But we certainly have notated that our Sexual Harassment Data Collection Act, which went into effect this FY, hasn't been funded by council. So would like to get a response to see if we can get funding for that, because that's going to be a new job for OHR.
Mm-hmm. I haven't looked at the FIS on that one, but do you have any idea how many positions you're expecting to need for that?
We asked for a couple, if my recollection serves me right, but the FIS did not grant any or didn't assess that we needed any, which we don't agree with.
Okay, so it's not subject to appropriations. It's just that you don't think you have the resources.
Yes.
All right, and that is something that you have requested already in your budget from the mayor?
I think this is something we've raised with the council, but I will double check with my budget team.
Okay.
I'm still a little green when it comes to budgeting.
A likely story. I'm not sure if I believe you because I know you've been around a while, but I'll give it to you for now. Okay, so in December, so we were just talking about this. So in December, the council passed the Domestic Workers Employment Rights Amendment Act, which provided important workplace protections. Let me see. I think I already got to all of this because we talked about it. You haven't begun work on the guidance because it hasn't officially gone into law yet. Is that right? Domestic workers. Okay.
And we haven't gotten funded for it
Yep.
yet.
Okay. And we'll come back to you once you have the money for that on the litany of questions that I have about its implementation. The council last received the annual language access compliance report in January 2022. The report gives this committee and the council at large an important window into how well district agencies are meeting the requirements of the DC language access law and the city's commitment of accessibility to residents with limited English proficiency or non-English proficiency. When should this committee expect to receive the next report?
I think we're looking at it very soon, probably in the next, within the next few weeks. I mean, it's very close to getting published. And we'll certainly, shoot it over to your office and it's published.
And what obstacles has OHR faced in delivering the report within the time period laid out in the regulations?
And I can only speak to the last year, obviously, but that had to do with transitions in leadership, right? And then layers of reviews that is required to produce publications. And one of the things I can tell you we tried to do in FY22 was to streamline to make sure that our information in all the publications were consistent with other publications, same quality level, same information level, accuracy, all of that. So that all takes a little bit of time, but as we have now provided a sort of a moving forward consistent template for all of these reports, then it should be a little easier for the next year around.
Okay, great. Thank you. Can you walk me through the enforcement process for the DC Language Access Act when you receive a complaint that a district agency is not in compliance with the statute?
Sure. I'm going to ask our Language Access Director, Rosa Carrillo, to go ahead and outline that. That way I don't screw anything up.
Good morning. It's still morning, just 1 minute before afternoon. That's right. Good morning, Councilperson Medea. Thank you for the opportunity. And could you just, let me see if I just get the right question. You want me to walk you through what's the process when we receive a language access complaint? Is that right? Okay. So if an individual file a complaint, the first process is that I will call and take immediate reactions in terms of calling the agency or the public funded entity or the fund or grantees or whoever is against the complaint for against, and I will make sure that the individual receive the service. That's the immediate response. Either I will call the language access coordinator, the point of contact for that agency or organization, and I will be seeking for immediate response. Either is providing a document translating in the language that is being requested or providing interpretation services. During that process, we also call the pre-investigation resolution process, where the agency or funded entity will receive a notice saying that, please, you acknowledge that there was a case that was a complaint filed against your agency, and you have the right to acknowledge or not acknowledge compliance. But in the meantime, the individual or the person who filed the complaint will receive the service. That's my priority when we process complaints. If the agency acknowledges compliance, then we just move to a corrected action. We're just seeking what is the steps, what corrected action plan we're going to establish so the agency will address those compliance gaps. If the agency or funded entity did not acknowledge compliance, says, no, we are in compliance, there's something wrong. So if there's no resolution in that pre-investigation process, we move that case through investigation. After the investigation, there is also whether the agency or the funded entity is found in no compliance, there will be a corrected action. Either way will be a corrected action. If found in no compliance, will be a corrected action to taking place. And that is basically addressing, again, any compliance gaps that has been found in that investigation.
You highlighted that your first order of priority is to ensure that the complainant does receive the services they are entitled to. And so how does that typically would be access to somebody in their primary language who can help them with their application for services in the government?
Absolutely right, yes. Most likely are documents or oral interpretation when they're going to, just giving an example, seeking any government program or services. Or it could be that they need to access applications online. The most recent that Director Khan just mentioned were resolved very quickly in the fact of a month with an agency where the district direct portal, there was a public complaint, and we addressed the issue that that site was not translating in Spanish and in Amharic immediately. It was in process to be translated, but it took a long time. So we immediately respond and meet with the agencies, language access point of contact and coordinators or any other key personnel in that agency that needed to fix that problem immediately. That was a milestone task that I think it was around 3 agencies that needed to be involved in that process. So that's the main priority. And this is thanks to the work of advocates. because an individual will not knock my door immediately and say. It was mostly because advocates will be supporting those individuals who were unable to access applications on those two languages in the district red portal. That's an example. It could be any other, like any other agency website.
I noticed that we've had a number of agencies that are taking advantage of the Google Translate plugin for websites to really fast track that language access. Has that tool been sufficient generally for constituents, or does it lack in some areas where we really need to be going deeper?
So the approach of the language access program with that dynamic, that has been really revamping at the time of COVID, because it has to be an immediate response, translating documents in immediate, like less than 24 hours. Agencies decided to move into Google Translate engine. And our approach has been a hybrid always. Google Translate or any other translation software that will not provide that accuracy in terms of, except that somebody will have to do some cross-check or proofreading of something that is being translated by in this case, Google Translate. But most of the time we ask them to be hybrid, because Google Translate don't have the capacity to translate documents that are in a specific format, like a PDF. And there are many informations from agencies that are already translating in PDF. So we asking agencies to, in addition to Google Translate engine and their website, have a section called the language support pages. So government agencies has a section, major public content in particular, has in their website, should have in their website, a section that calls language support pages, where individual will go and see Spanish, Vietnamese. It depends on the language that the agency meets the language threshold. And they will store or upload those documents that are translated in those pages.
Very helpful, thank you.
You're very welcome. Soon we'll have the training for language access with City Council, so there'll be more information provided there.
Yes, it's very exciting. Thank you for offering that. We are having a training for DC Council members and staff on language access in an effort to ensure that all of our materials are more accessible to the public, because there are times where we think, oh, the statute doesn't apply to the legislative branch in the same way, but you know, my push is going to be for everybody to understand the importance of language access, regardless of what the statute says, and also, you know, in an effort to make ourselves more accessible to the public, we should always be striving for that. So very excited about that training. Thank you.
And I applaud that effort.
Thank you. Thank you so much. Okay, Rosa, thank you so much. Director, in June of last year, the council passed the Human Rights Enhancement Amendment Act, which created protections from discrimination for people experiencing homelessness and clarified the city's definition of workplace harassment. I was pleased to read and hear that in December, your office released guidance documents and held the first open house on the expanded definition of workplace harassment. Remind me, please, does your office plan to hold additional open houses during FY23? And if so, please share any scheduled open houses that we can discuss.
Yes, indeed. We're going to be holding open houses quarterly throughout the year. And so we will definitely let your office know.
Okay, quarterly. What initial feedback, if any, have you received from employers adapting to the new definition?
I don't think we've received any yet, but you know, we're still making our way to collecting those feedback and thoughts from the community.
Okay. During the last council period, the council passed 2 laws for which OHR had been assigned as the enforcement agency, but which the office noted in its pre-hearing responses were unfunded. One, the Cannabis Employment Protections Act and the Medical Necessity Restrooms Act. Has the office been able to take any action towards implementation?
No.
Do you happen to know what resources are needed in order to implement these 2?
I do. I think we requested probably a few FTEs. If you give me a few seconds, I can look it up now or follow up with you later, whichever way you prefer.
Might as well just do it now.
Okay, let me go ahead and look that up. Give me one moment. It's coming up.
Great.
All right. So let me. All right, so this was medical necessity. We asked for 3 FTEs. I think the FIS indicated 2 FTEs. And then I think we'd asked for $175,000 for the portal and $44,000 year after and $5,000 for outreach. And then cannabis, 2 FTEs, one to be a hearing examiner, the other to be legal support, and then about $100K for training and equipment. So I think with that one, the FIS did agree. It's just not been funded.
Okay.
And Elizabeth will chime in if I'm incorrect, but I think it has not been funded.
We'll get back to you on that. Yes.
Okay.
2 more questions from public testimony today before we conclude. We received testimony today from public witnesses advocating for more directors' inquiries on the issue of systemic housing discrimination. Do you have thoughts on that?
Yes, just the overall, my mission is to do more director inquiries. And so I agree that we should do more and we will do more. Again, you know, there's so much we want to do, just need capacity. So as we're rebuilding, please be patient with us, but we do want to do directors inquiries and we're always on the lookout for it. And in our HRL trainings, we always say, you know, these are the kinds of cases that would indicate a director's inquiry and we'd love to have it. So we're getting out there. Please, if you're out in the community, let folks know we're interested in doing director's inquiries and we'll be pursuing them.
Will you explain to me what that entails?
Yeah, I was thinking for a moment, should I mention what they are? So director's inquiries are basically, as the name suggests, an inquiry into a complaint or incident that we might want to look into sort of unofficially at first. And then if there is cause to believe that this is something that we want to pursue, then we would do an official charge of discrimination. We would docket a charge of discrimination. So the difference between DI, director's inquiry, and something else is that, for example, if you were the individual complainant, it would be Nadeau versus McDonald's, right? But we don't need a complainant in order for us to pursue. If we hear from the community, sorry, McDonald's, to use you as an example, that there were some issues at McDonald's, we would go, this would be, you know, OHR versus McDonald's. So it would be us taking up these complaints in the public interest without having to need an individual complainant. And we sometimes do get information about how individual complainants don't want to engage in this sort of public legal process. And so they want to tell us about the issues. So we'll look into it. Does that help explain a little bit? I'm trying my best to.
Yeah, no, it does. It does. It sounds like it gives you a lot of leeway to sort of look into something, you know, it may be, I imagine there's a lot of people who don't want to go through the formal complaint process. And there are other law enforcement agencies that don't have the opportunity to look into something unless a case has been filed. So this does sound like a pretty poetic way of looking at something that you think is an issue, even if you don't have somebody willing to put in the case. So that's really interesting.
Yeah, and you know, we, for example, have done DIs in FCRSA where we might not have found probable cause in an individual case, but you know, the issues raised in that case still gave us pause. So we wanted to dig into it and look into it. So we then would issue a director's inquiry to look into that issue.
Great. Well, I look forward to more of those as you stabilize your growth. We also received testimony about the Office of Human Rights not accepting racial discrimination complaints based on disparate impact analysis, even though they allow laws for it. What is your response to that concern?
So I think I've mentioned before that in prior years that the reason is because it's very resource driven in order to engage in disparate impact cases. We have to get into statistical evidence. That's what the law requires in order to see whether there is an impact on an entire protected group. Right. So if it's race, if it's sex, we have to say all the females or all the males or all the, people of a certain color or race are being impacted. So that requires collecting, massive amount of data and not analyzing it. And so, considering our cases are very complicated, we don't normally take disparate impact cases. But I've said before, and I'll say it again, if community members have a particularly egregious, disparate impact case, we will certainly partner with folks like EEOC to combine resources to work on them. So it's not a never, it's just that we don't normally. And certainly at this point, OAG is a venue to pursue those kinds of cases because they're interested in pursuing public interest and these kinds of, pattern and practice cases that would arise from these sort of disparate impact cases. So, we're not, we don't want to not help in those situations. We want to help, but it is important that folks let us know when those kinds of cases are bubbling so that we can help one way or the other.
Great. Thank you. Anything else you want to add before we conclude?
Yeah, I just recall that one of the community comments from Mawila was about attorney drafted charges. I want to just say, for the record, we're happy to work with Mawila on that point and see how we can progress together.
Great. I love it. Thank you. Thanks to you and your whole team for being here today. We really appreciate the testimony and looking forward to working together.
Thank you, Chairperson Nadeau. Really appreciate your time as well and your leadership. We look forward to working with you.
Thank you. This concludes today's public oversight hearing. If you plan on submitting written testimony for the record, a link will soon be added to my website at brianneknadeau.com/committee, where you'll be able to upload your PDF or Microsoft Word file. The record for this hearing will close at 5 p.m. on Thursday, February 16th. I'd like to take a moment to remind you that the Committee on Public Works and Operations will be holding 4 more performance oversight hearings. Next Wednesday, February 15th, the oversight hearing on the Department for Hire Vehicles, starting at 9:30 a.m., followed by the Department of Public Works. On Thursday, February 16th, this committee will join the Committee on Transportation and the Environment to conduct a joint oversight hearing on the Deputy Mayor for Operations and Infrastructure. And on Wednesday, February 22nd, starting at 9:30 a.m., the committee will hold performance oversight hearings on the Office of Contracts and Procurement, the Contract Appeals Board, and the Office of the Chief Technology Officer, and the Department on Licensing and Consumer Protection. If you would like to testify at any upcoming Public Works and Operations hearings, you can sign up on my website at brianneknadeau.com/testify. The time is now 12:16 p.m. and this hearing is adjourned. Thank you.